This program is made possible by the New York law firm of Zalman and Storman, who specialize in the field of personal injury law. Welcome to Law Line with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Law Line will bring you the most knowledgeable experts in the field of law today. And now we introduce our guest and our host, Alan Schnorman.
Welcome to Law Line. What role does a trial judge have in the settlement process? Today we'll look at that issue with our guest, the Honorable Stuart Cohen, Acting Justice of the Supreme Court, New York County, and Richard Godowski, a partner in the law firm of Damashek, Godowski, and Gentile. Richard represents plaintiffs in major negligence cases. Hello, Judge Cohen. Hello, Dick.
Hi.
Judge, when is the best time for an attorney to settle a case?
Well, in New York County now we have tap parts, and there will be many opportunities to settle cases before you go to a trial judge. A good time to settle a case is the first time that you see a tap judge and when your case is on the calendar.
But you know what? I have a problem. The tap part is really an assignment part, and although Judge Cohen can only reflect on his own part, some judges don't get the respect of the lawyers. But where a judge makes a recommendation, and somebody says, like this guy Bernie London, who represents the city of New York, he takes those recommendations seriously, but other judges don't really want to make recommendations, they don't pay attention to it, they don't really look at the cases, so it takes a longer period of time than that first meeting for the judge to become equipped, making notes about every case, and then saying, well, what do you want? Well, I want $2.5 million. What do you want to pay? I want to pay $25,000.
Judge, but how do you know what a case is worth? I mean, you must handle so many cases before you. How do you know one broken leg is worth so much for a recommendation and a broken arm is worth another totally different number?
Let me get back to the first question and let me ask the second question. It's very difficult for a case to be settled before it gets into the tap part because, at least it's my experience in the cases that I'm seeing, that a lot of the cases are not even prepared for trial when I see them, so they certainly are not prepared for settlement. I get a lot of cases now in which even discovery has not been done. As to how much a case is worth, to be very frank about it, cases are settled by defendants. So you have to determine what the defendants are doing. If you want to settle cases, you have to have the respect of the defendants and the plaintiffs, and that's the way cases get settled. And the injuries as such, every case is unique, and I don't think you could put a dollar value on each leg, on each finger, or whatever.
We had one judge on the show who said a case gets settled when fear, and let's see the word is, when fear and greed merge. Do you agree with that?
No, I wouldn't agree with that. I think that if both sides are prepared, if they know their case, they should be able to determine what it is that would be a fair settlement. There are a number of problems. It is true that if you do not settle the case, there may be a very large verdict in either direction. It may be to the disadvantage of the plaintiff or to the advantage of the plaintiff. So there is a number which can be determined, and I think that a good plaintiff and a good defendant should be able to figure out the number. I don't think fear and greed are the big things.
Dick,
no.
How do you know the right time to settle? How do you know when you got that last $10,000 on the case?
You know, probably by convincing myself abstractly that I've gotten it, and many times I'm sure I haven't. But you know what? There really is a great deal of talent, in my view, more so in settling cases than trying them, and I try a lot of cases, because as you know, and as Judge Cohen knows, there are some people that are very adept at negotiating the same case, the same injury, the same liability, the same courthouse, the same type of juror, and one lawyer will negotiate and get $250,000, another negotiating lawyer will get $75,000.
Let me ask the judge that. How important is the attorney in this whole process?
The attorney is very important, especially as far as preparation is concerned. If within limits, good attorneys, well-prepared, should do about the same. I say within limits, good attorneys. Now, that may not be the case in every instance, but if you have a prepared case, I think you should do about the same.
Well, defendants or insurance companies, will they offer an attorney who has a wonderful reputation much more than an attorney who's basically maybe not as experienced?
I've never been on that side of the fence.
I must admit to you, Alan, as you know, and Judge, that for many years I did defense work, defending insurance companies.
For more years than you represented plaintiffs.
That's true, and found out where truth and justice really lie. But in any event, came back to look at my files when they were assigned to me, and most lawyers might look at what is called the bill of particulars. That is, what are the injuries, what is the claim of responsibility. I look for the name of the lawyers. I look for the lawyer who I knew would take a case to verdict to see whether or not I'm going to settle the case. Too many lawyers come to court to settle the cases, and they lose them. The lawyer that comes to court to try the case settles it for substantial monies. And it's only the big names or experienced lawyers who get that reputation. It takes time.
Some attorneys feel the best time to settle a case is after they select the jury and they show the defense, they show the insurance company that they're ready to go. How do you feel about that, Judge?
I really, if you are picking a jury and if you've opened to the jury, I would think that at that point you are seriously thinking about trying the case. I am running across more cases now of people who are picking juries and are opening to juries, and I don't know how well prepared they are. I would think that the better time to settle the case is before you go through this. And also, I must point out there is tremendous expense now involved in trying cases.
Judge, what do you do when you see an inexperienced attorney trying a case and he's losing a case that he should be winning? Do you try to help him out? What's
Not allowed to do that. Now, I would just point this out, that I did a lot of trials. Now I do not do trials. I am in a conference and assignment part.
So you assign the cases to other judges?
And basically I'm settling cases. I'm settling a lot of cases. That's what I'm doing. No, there is no way that you could help out an inexperienced attorney. You really can't do it.
Dick, what is a case worth? I mean, what is a broken arm worth? What is a broken leg worth? What is a death case worth? How do you determine that?
You know that there are variables, and infants and elderly people who get seriously injured, for the same injury, the elderly person gets a lot less money, at least in the abstract, because they have less years to live and therefore less time to suffer. I want to tell you that the fact is that what makes the value of a case is the preparation of the lawyer, the fact that a doctor has written a very solid report, that the lawyer has conducted a deposition knowing what he or she is doing, and even more significantly, the lawyer knows what value is, so that when he or she goes before Judge Cohn, he doesn't say, for a fracture of a finger, "What are you looking for?" Judge Cohn says to the lawyer, and the lawyer says, $25 million. You know that that's not going to lead to a viable discussion, so that the lawyer who really is able to fix on the value of a case and make it high, but still be able to settle it within the limits of what is reasonable, I mean high reasonable, is able to convince Judge Cohn.
Judge, do you make recommendations of settlement to attorneys?
I make recommendations to attorneys when, after I've spoken to both sides, I ask permission to speak to both the plaintiff and the defendant. I see what their position is on the case, and I have some feel as to where, excuse me, as to where the case is. At that point, I'll make a recommendation.
Is that usually a compromise position between the attorney for the injured party and the attorney for the defendant?
It doesn't have to be a compromise position, no. No, it's based upon a number of cases I've seen, where their positions are as to what I think may be fair. I do make recommendations, yes.
Now, Dick, I see some verdicts come by down $100 million, $180 million. What happens to those cases?
Well, they do get reduced. The highest standing verdict in the first department is $14 million. And those two cases, one tried in New York County by a lawyer named Ivan Schneider, and one tried in Queens by Harvey Weitz. They happen to be partners. Those verdicts will be substantially reduced, but my guess is they're both going to be settled. And those cases offered specific problems where it wasn't the dollar value that precluded them from being settled. It was the fact that each defendant said the other one owed the money, so that no one could get together.
So now, you say here the largest verdict sustained, at least in our area now, is $14 million.
Correct.
What kind of case was that?
It was a construction case, so there was no issue of responsibility under the law. It was a quadriplegic who was brain damaged as well, with substantial earning capacity and a family to support, and would never work, live very well, 24-hour medical care for the rest of his natural life.
Well, what
Can
type?
I
Yes,
just
Judge.
interrupt for a second? I think I had the largest settlement of a case, and that was for a little over $9 million of fresh money, and that was settled for $9 million. It was also a situation in which somebody was in the Rusk Institute and had to be turned every hour, and they felt it. And the amount of money that would be required for that person, and a very young construction worker, was going to be.
So in other words, a
$9 million.
substantial part of the $9 million basically was just going for medical bills.
Yeah, but I think that was the largest settlement I've ever heard of. That was in my part. A little over $9 million.
Was that after trial?
No, a settlement.
That was before a jury was selected?
It was after the jury was selected, but before the case really went anywhere.
Let me ask you this, Dick. Regarding these large verdicts, what type of jurors do you look for who would be sympathetic to your position representing the injured party?
Well, Alan, you know that jury selection is a great deal of gut reaction, but it's also a question of identification. What kind of client do I have? Do I have a very rich client? Do I have a client who's a minority group? Do I have a client who's a drug addict and who the drug addiction has nothing to do with his injuries? I have to look for people who will understand what the law is, and I have to press upon them the fact that they have to listen, take the law, and follow it. I don't believe that there's a good juror in one case is always a good juror in another case. I think each case requires special look into the juror's mind.
Now, Judge, I know the attorneys select the jury outside of the judge. The judge is not present when the jury is selected for the most part.
Yes.
And each attorney has a certain amount of what they call peremptory challenges. That means he doesn't have to give any excuse why he wants that particular person off. But the question I have is, can an attorney, let's assume, exclude, let's assume, all blacks from the jury because he feels that the plaintiff is black and those jurors will be sympathetic to the plaintiff?
Yeah, I was going to interrupt you before that. The statement is not accurate. You cannot use a peremptory challenge on a juror for discriminatory purposes, and that there's certainly any number of cases on the criminal side, and there are any number of cases now in the civil side. We have hearings on that. They're called Batson hearings, and you cannot you cannot disqualify a juror for that reason. I will. Since we're getting to the question of jurors, it is very important now that jurors be permitted to sit and that we utilize as many jurors as we can. So I think that even in the state system, we're going more towards the federal system, whereby we are not permitting jurors to come and just not be used on juries. And I think you will see that there'll be the stricter application as far as peremptory challenges are concerned.
Let me ask you that. In fact, there's certain jurisdictions here in the state of New York that if a juror shows up one day and he's not actually used on a jury, he's excused. Now, of course, that's not the case.
We couldn't
here.
do that in New York County. We would not have that many people. But in very serious situations, when the attorneys cannot get together, juries are picked, even in civil cases, in front of judges. And I will tell you right now that those cases the jury selection is very, very rapid in those instances.
That's
Well,
understandable.
Very rapid.
Well, that's in the federal system.
No, in the state
I understand, but the federal system...
The federal system, and also in all criminal cases, it works that way.
Dick, what type of people do you look for as far as occupations? If there's an attorney out there who's trying his first case and he's representing an injured party, what would be your recommendation? What type of occupation should he look for, or she look for?
Let me tell you how to do that, and that is by eliminating those occupations that tend to be more sympathetic to a defendant for various reasons. Those people who work for public utilities, who either get stock in those companies, go to safety lectures, are told that people are suing them all the time and to be very careful about lawsuits, about reporting accurately, but even more significantly telling them that those lawsuits take dollars out of your pocket because your stock that you're getting from either the utilities that supply us with electricity, with telephone, those people are poor jurors, as are accountants and engineers who deal with numbers and specificity during all of their careers, but never deal with the real human values and the movement and the time and the lapses that people might have. They expect perfection, and there is no perfection in a trial.
Now, are there certain places in New York City that are better to select a jury than other places?
Well, historically, and in the history of the last 15 years, the best place for someone to sue for personal injuries, not in every case, but in most cases, is Bronx County in our metropolitan area, an area that is predominantly minorities.
We have to take a break now, but Judge, I'm going to ask you right after the break. A question is, what if a jury brings in a verdict that you're shocked by it? Let's see if can you do anything? Okay. We'll discuss that right after the break. You're watching Lawline. I'm Alan Schnorman, your host. Stay with us.
After dating the guy forever, you think I could tell him anything.
Why is this so hard? I'm really scared.
It takes a lot of guts to tell someone he's too drunk to drive. But you can do it. Just say it. Because if you don't, there may be nothing left to say.
Kevin, I'm gonna drive.
Take the keys, call a cab, take a stand. Friends don't let friends drive drunk.
When your employees train with the National Guard and Reserve, they learn to be better team players, better decision makers, and better leaders. It's training that makes them better at serving our country. And better when they come back to work for you.
Bill's back.
Be a hero. Give your employees the freedom to protect ours.
Hello, I'm Alan Schnorman. You're watching Lawline. Today we're talking about personal injury cases, what your case is worth and what any case is worth. Our guests are Judge Stuart Cohen, the acting Supreme Court Justice in New York County, and Richard Godowski with the firm of
Damashek, Godowski, and Gentile.
Okay, Judge, right before the break, I had asked you, what happens if the jury comes back and you're just sitting there and you go, my God, they didn't even listen to the evidence. I don't know what to do. What can the judge do?
Well, what normally happens, and this is in every case, that once the verdict comes in, whichever side is unsuccessful asks for time to submit motion papers in order to set the verdict aside. I would say in 9.99 out of 100, the papers never come through because both sides are satisfied with the verdict or do not wish to appeal it or to make any question about the verdict. In the few instances in which either one of the parties feels that something has happened that shouldn't have happened, they make an application to the court first. I will listen to it, and if in fact the verdict is incorrect or if there is some problem, or in a lot of instances you may ask the jury a lot of questions. The answers to the questions may not be consistent. There may be a lot of reasons why jury verdicts have to be set aside. I will listen to it, and then I can set aside the jury verdict. Now, in either instance, whether I set it aside or not, there's always the opportunity for appeal by either one of the parties.
That's the appellate division.
The appellate division, yes.
And
out of Supreme Court, appellate term out of civil court.
And basically, is it the appellate division the one who determines these large verdicts, what they should actually be?
Yeah, that's one of the ways of putting it. Yes, there is a standard. They have cases. They have precedents, and in each one of the departments, they've determined, what the limits of some of these verdicts should be.
I'm not convinced that the appellate courts are as wise as we make them sound, simply because the cost of medicine, the loss of earnings, the parental guidance that sometimes becomes a factor for children who have lost their parents, the loss of a wife or a husband, the matter of companionship causing psychological injuries rather than physical injuries, has become a major factor in projecting damages, not only for lawyers, for insurance companies, but for appellate courts as well. And hopefully they will understand, and slowly but surely they will, that those injuries are as serious as physical injuries.
Dick, let me ask you this. A person dies involved in an accident. Well, how do you calculate the damages of a person who's passed away?
We are known as, and I hate to use the word because it's become part of my vernacular, a pecuniary loss state.
What does it mean?
There is recovery only for the actual dollars that person would have provided, with some definitions of pecuniary loss, such as the child losing the guidance of a father is termed a pecuniary loss in New York. Other states have emotional loss, grief. We don't award that, but we will award lost earnings over a lifetime, the cost of bringing up those children if that person was alone, the fact that the child went to church or to synagogue with his mother or father who died. The bonding issue has been determined so that our appellate division, First Department, has affirmed for a mother of 20 years old with a 1-year-old child $2,600,000 on a bonding and nurturing issue that child could never have again. And I tell you, a concept that didn't exist 10 years ago. Court of Appeals last week found that people could sue for electric lines that may be depreciating the value of their property for electromagnetic fields that might cause injury in the future. So we are becoming a little better than we were in the past, and a little more up to date, and a little more understanding of human suffering.
Of course, that's because of the new technology. Would you agree with that? I mean, years ago, we didn't even know that electric lines may very well, whether they affected people
We used
living
to
there or
think,
not.
I would think that we would have thought years ago that only nuts and crazies would say they were affected by electromagnet systems running from telephone lines, television sets, X-ray machines, to go a step back. And the fact is, yes, it's technology, but it's also the ability of lawyers to understand that technology, which is another step away.
Judge, what are you doing? You're trying a case, and the attorney is acting inappropriately, is being unruly. How do you handle that?
I think every judge has to determine that for themselves. I must say that in most instances I have a very quiet, pleasant court. It really shouldn't happen, and there are ways of making sure that it doesn't happen. I have occasion to lecture to judges, and I will tell you what I tell judges in instances like that. I feel if something like that happens in the courtroom, that the best thing for the judge to do is to send the jury out and for the judge to take a little walk down the hall. I must say I've been doing this for a while, and it is very, very rare that I have that problem. I think that most judges are able to control their court, and that's really not a serious problem.
Dick, let's ask the opposite side of that coin. You're trying a case, the judge doesn't like your case, the judge doesn't like your client, and maybe the judge doesn't even like you. And you feel that your case is being prejudiced by that. How do you handle that?
Well, I handle it in one way all the time. That is that, Alan, that I want the jury to understand that I'm being trod upon. And I make sure they understand it because I maintain my respect, perhaps not for that judge, but for the position he or she holds. But I tell you what I really do. At the closing arguments that lawyers give, I spend a great deal of time telling the jury that they're going to make the determination in this case concerning all the facts, and I point to the judge. And whatever that judge says the facts are, you can disregard it. I want them to know right then and there that we're at war with that judge, and they shouldn't allow it to happen.
Is that correct? If a judge tries to tell the jury what the facts are, it's the jury's recollection?
Yeah, that is correct. The only thing that the judge could tell the jury is what the law is. And the judge, on the other hand, will tell the jury that it's the judge's province to tell them the law. They cannot speculate on the law. As far as the facts, it's for the jury to determine the facts.
Some judges on our show over the years have felt that the public's image of the judge has changed over the years. It's not the same way it was 20 years ago. How do you feel about that?
20 years ago, I was trying cases. I've only been a judge for a short period of time, 6 years, which is a short period of time for me. I suppose the dynamics are different. I would think one of the reasons of the difference in the dynamics is the fact that there has been a lot more litigation. I think we had a more serene legal situation 20 years ago. If you realize the volume of cases we are now handling in New York, I suppose, like with everything else, there has been a speed up in the amount of cases and what's taking place. I can't really say that the attitude is different. As I said before, every judge has to determine for themselves.
What do you think, Dick?
I think that the judiciary as a whole has become less receptive to the problems of the public. I think that the problems of moving calendars, of statistics of how many cases have been settled or disposed of, rather than the quality of justice, is starting to mount beyond anyone's belief, so that the question of whether a judge has the time to give to the cases that they once did as a result of litigation is affecting all the litigants, plus the fact that criminals have not only affected our lives on the streets, they've affected our lives in the courts.
Were there any surprises when you took the bench, or did you basically know what was going to come?
I had done a lot of trial work before then. I had a good idea of what was going to come. If I could just comment on what Mr. Godowski said, I think we both said the same thing in a different way. I think what's happened is that we have an increased volume, that the court system has gotten a lot quicker paced, and if it may be that that's something that that government has to look at and see, maybe there has to be more people.
Let me address that. If I gave you the power of the legislature, the power of the executive, how would you change the laws to make the courts better?
Oh, I think well, if you want to get into that in the last couple of minutes, I think the way our system is now, with the different courts, make it very difficult for the administration to place judges in various places. I am for court merger. I am for a system that permits judges to be placed at the place where they could work the best, and to a certain extent we're doing that now. I think we're a little too cumbersome now.
Right now, judges are elected to civil court, judges are elected to Supreme Court. Now, there's a whole movement regarding merit selection. What's your opinion regarding election versus merit selection?
Let me just say this. In the criminal side, they are selected. They are not elected. We have to have a combination of merit selection, and I think in some instances, some elections. I'm not opposed to the system we have now. What I am opposed to is the fact that we have artificial strictures on where judges could sit, and if we had a merger, a one-court system, I think that we would be able to use our personnel a lot more effectively.
But isn't there been criticism that way, where a Supreme Court judge says, well, I'm not going to sit in small claims court, and I'm not going to sit in landlord-tenant court?
Well, I'll tell you this, if you're asking that question, the most fun I think I had was in the Harlem Small Claims Court, where I went out of my way to sit. I think most judges would sit any place.
Dick, how do you feel about this merit selection versus appointment process? What's your...
I think that it's a facade. I think both are political. The merit system being...
I see the judge shaking his head. Okay.
No, I'm not saying, no, I'm just...
The fact is that merit means that the governor or the mayor or the legislature or somebody who has political input gets to be a judge, and the fact of the matter is, I want to leave it to the voters. I want those people, I want them to have more knowledge. I want the New York Times to publicize it. I want them to be on programs like Lawline. I want the people to know who they're electing, not the backroom politicians.
Can I just say one thing?
Quickly?
I was elected, and my first election I won by 6 votes, so I am certainly for the election
Judge
system.
Stuart Cohen, thank you very much for appearing on Lawline. Dick Godowski, thank you once more for appearing on Lawline. And
Thank you very much.
as always, this is Alan Schnorman, and thank you for watching Lawline.
You have been watching Lawline with your host, New York trial attorney Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions about this week's program, please write to Lawline, 63 Wall Street, New York, New York, 10005, or call area code 212-432-9111. This program is made possible by the New York law firm of Zollman and Schnorman, who specialize in the field of personal injury law, located at 63 Wall Street in New York City.